Good morning, Commissioners. My name is Pat Johnson. I'm founder of Texas Towing Compliance, and I hear from victims all across the state every day. I've got quite a bit of stuff to talk about, but I'm going to talk about some of it. There was a recent regulatory interpretation by TDLR that punishes the honest and law-abiding towing and storage companies. Storage facilities are supposed to accept people's credit cards. That's fair, but a new regulatory credit cards that belong to other folks other than those retrieving their vehicles. Such transactions increasingly result in chargebacks and penalties assessed by their financial institutions regardless of the legality of the tow. Is it fair or wise to subject vehicle storage to this financial hazard? Ask that you please reconsider this and remember this for society's benefit. Another thing I'm hearing about is people have no way to check the status of their complaints when they file. Whenever they do get a hold of someone, they're not told anything. But if we want people to continue to file complaints against licensees for committing rule violations, and then you get letters, I got a letter back from on A&A and another company called Customs Record Service that operated without a license for close to 60 days. Seen their trucks running up down the road, so I initiated a complaint, and I get a letter from your agency that says I had to provide you proof that they were operating. When the police department presented all the documentation during that time period to enforcement at the time, but they rejected complaint because I can't provide. If we want people to file complaints based on what your database says when someone is operating without a license or a suspended license, and then you provide information based on your criteria on your database that says they're operating without a license. Well, what gives there? It doesn't make any sense. Another thing we got concerned about, and TDLR, y'all know you can do something about this without legislative approval. Stopping these companies that owe you, like Merlin Transport. You fine them $21,000 and they ain't paid zero. And they're creating another company to move all their equipment over to another company called Tarrant County Abandoned Vehicle Removal, Inc. And I guess they're going to talk about rearranging the deck chairs on the Titanic. Another issue, municipalities I've talked to said TDLR's website doesn't go far enough in the final orders when you look up violations of a licensee. It only lists a little bit small detail of the violation. So someone could collect on the tow case number, so to bring up the PDF file so other companies and licensees can see what violations their competitors are being cited for, so they don't fall in the same criteria of getting fined for creating the same violation. Does that not make sense, Mr. Denton? Other than that, you know, over in San Antonio, towing companies continue $85. And if you recall, it was John Deloach that sat right here in front of you that day and told you that if he didn't have $250 when the tow fee study didn't even set the tow, that he was going to go out of business. And having to charge $85 and with close to 400 citations for charging in excess of the city ordinance violation. And it doesn't do absolutely no good to file complaints because TDLR nevertheless allows postponement after postponement without charging the towing company in the storage facility for that time that we have to use staff to move them over. Why do we have baseless continued postponements when the victim, they don't get no postponement? They have to pay for their car right then or they lose their vehicle. What's fair is fair. Next, are such administrative trials handled even with? Why should the accused get continued depriving their victims of their right to a speedy administrative trial? It takes about a year to emerge from through TDLR. A smallish amount, settlement amount, be work that taxpayers say TDLR do. You know, he sets extensions. So why does TDLR nevertheless postponement? We want to cut them. I told us in the previous meeting, we need to stick with these fines. Fines is the only way you're going to get their attention. They're going to keep coming. And you're going to sit out here and whittle that fine away, just like that signature case. It started at $4,000, then we got it all the way down to $2,800. Rolling out of their apartment complex because they got stickered instead of getting the certified letter. The certified letter, and of course, Mr. Raby, if you understand the last meeting when we talked about the expired inspection sticker scam, the sticker does not mean anything for an expired inspection sticker. It might be good for a flat tire or leaking fluids or something like that, but an expired inspection sticker, you could cover the entire car in an orange wrap, vehicle wrap. The law requires that the parking facility send that certified letter, not the towing company. It has absolutely zero to do with the towing company. We did it for a specific reason, because the towing industry wanted to make that money. They're still making that money, and they're getting away with it because the public doesn't know. So let's have a good week and a good summer. I don't really have much to say, Mr. Dent, other than same thing every year. We just want more information to be allowed to the public. When you click on search violations by licensee, you ought to be able to click on that journal order and see what it is that you signed and Mr. Kuntz signed, finding these people so they know what their competitors are doing.
Thank you, Mr. Johnson.